Good morning, everybody. We are here with our speaker, Ralph DeMeo, and we are going to be talking about a very timely topic, which is the key legal issues associated with hunting, fishing, and trapping in Florida. And I say that this is very timely because there's a ballot initiative coming up this year that you'll see if you are voting in this year's election. And this will hopefully help give some background, some context, some history for that may help you make a decision on that one. I will give you a brief introduction to Ralph if you don't know him yet. And I will give you the CLE course number at the very end of this presentation. You can use the chat feature or the Q&A feature to ask questions throughout the presentation, but I will wait until the end to get to them. And if I think that they're being answered on screen, I think there's a way for me to mark that as well. So if you do have questions, feel free to type them in at any time. But just know that if we aren't answering you immediately, don't lose hope. We will probably get to you towards the end of the presentation. So with that, our speaker today is Ralph DeMeo. He's a shareholder with the Tallahassee firm Gill Law. He's a graduate of Stetson University and FSU Law. He has 40 years of experience in environmental law, including marine and land wildlife and their habitats. He is a current member of the Executive Council and a past chair of the Animal Law section, and he is a frequent author and lecturer on environmental and animal law, and an adjunct professor of animal law at FSU Law and Stetson Law. And I wanted to also mention that we are very grateful for our partnership with the criminal law section this morning. If you are not a member of criminal law or animal law, I would highly encourage you to join both. There are regular free webinar series available to members of either and both sections. So feel free to cross-pollinate. We'd love to have you. And with that, I will turn over the presentation to Ralph.
Thank you, Laura. And Laura's our very esteemed chair and has helped us with these programs. And I want to second the welcome to our friends in the criminal law section. We're always happy to collaborate. This is one of those topics that cuts across a lot of different practice areas, including animal law and criminal law. And as Laura mentioned, it's especially timely because a very significant constitutional amendment will be on the ballot on November 5th. And we're going to talk about that more in a minute. Let me start with just giving you an overview of hunting and fishing in Florida. Hunting and fishing are regulated by the Florida Fish and Wildlife Conservation Commission, or I'll refer to it as FWC. Among its key activities are hunting permits, seasons, allowances, and other matters relating to the practice. We do have a very extensive wildlife code, which is found in 68A of the FAC, which regulates most of these things. I put up on the screen the different groups, regional offices of FWC. Of course, the headquarters is here in Tallahassee. You see the list of commissioners and the executive directors, and then the different regions. So this is a very important agency in Florida because of the vital role they serve in the area of hunting and fishing and wildlife conservation. Just again, very quickly, the FWC issues a variety of licenses: hunting, deer permits, turkey permits, migratory bird permits, crossbow seasons, archery, management area, and other permits relating to species, location, and method. And I've given you the references here, the citations to the key laws. I found these statistics very significant, kind of surprising when I first learned about this. On the left side, you'll see that we have 242,000 hunters that are regulated. And then you see the anglers broken down by residents, non-residents, pretty large number. Saltwater residents, 1,390,000 anglers. And then, of course, at the very bottom, and I count myself among them, the 4 million some wildlife watchers. It's a massive, important area for the economics. more than $15 billion into the state annually. It has both practices have been used as a method of conserving wildlife to maintain healthy populations. Much more on that later. And we always emphasize the needs of the environment, wildlife, and people to balance when you look into the issue of hunting and fishing. Okay, well, let's talk a little bit about some of the methods of regulation of hunting. For one thing, they're often regulated based on the species. So, for example, for fur-bearing species, you see the long list there. There are approved methods for hunting, including use of guns, live traps and snares, recorded game calls, but there are also, importantly, prohibitions against certain types of hunting, such as steel leg hold traps, dog-proof raccoon traps, body grip traps, and then there are also restrictions on use of lights from moving vehicles, and also species-specific restrictions such as foxes. Okay, now we'll focus a little bit on some of the methods that are banned by the FWC before we get into some of the specific laws. For game mammals and resident game birds, some of the methods that are prohibited, and some of this you might find interesting, I did, hunting wild turkeys with dogs is prohibited. Taking or attempting to take with live decoys, recorded game calls or sounds, set guns, artificial lights, etc., using fully automatic firearms, explosive or drug-injecting arrows, shooting from vehicles, power boats, or sailboats moving under power. You can, motor out to a place to hunt, but you have to stop before you actually do the shooting. Herding or driving game with vehicles, boats or aircraft. So it's a long list. I won't go over all of it, but it does show you that there is a lot of thought put into these regulations, and the intent being to conserve wildlife by not allowing excessive hunting abuses. Okay, well, that's just a very, very quick overview of some of the regulations. But let's talk about some of the specific laws, and that will segue into the Amendment 2 issues that we're going to finish up with. The very first thing to understand is hunting and fishing are public rights, okay? You'll see the statute there, Section 379.104. That's a current statute in the law. The right to hunt and fish, set forth very clearly. The legislature recognizes that hunting, fishing, and the taking of game are a valued part of the cultural heritage of Florida and should be forever preserved for Floridians. The legislature further recognizes that these activities play an important part in the state's economy and in the conservation, preservation, and management of the state's natural areas and resources. Therefore, the legislature intends that the citizens of Florida have a right to hunt, fish, and take game subject to the regulations and restrictions prescribed by general law and by Section 9, Article 4 of the state constitution. So I want to, again, emphasize the fact this is current law, okay? There's a right to hunt and fish that's been in the Florida laws for a long, long time now. It's never been questioned. It's never been challenged. Okay. As I mentioned earlier, FWC is the principal agency that is responsible for fish and wildlife resources, and that is constitutionally based. Article 4, Section 9, okay, which gives the FWC the specific authority to regulate marine life, wild animal life, and freshwater aquatic life, okay? So again, want to emphasize, we have in our current Constitution the establishment of this significant agency, one of the very few that's established by Constitution, not just by statute, and it very specifically conveys this authority to regulate marine and wild animal life. Okay, so let's kind of segue now into the criminal side of this. What I just mentioned up till now was the civil side, if you will, in terms of permitting and regulation of certain hunting and fishing activities. But very important to understand that there are specific criminal penalties for violations of the criminal laws in the Florida statutes. So let's start with kind of the basic one, Section 379, 401. And these, the crimes, like in other contexts, are categorized into different levels. So a level 2 misdemeanor is when a person commits an illegal trap, a use of dogs to take wildlife, tagging requirement violations, hunting in restricted areas, violation of bag possession or size limits. These types of activities, when violated, constitute a level 2 misdemeanor under the Florida Criminal Code, specifically relating to hunting. Okay, we also have a level 3 misdemeanor found in 379.4013. A person commits a first-degree misdemeanor for the possession and transportation of commercial quantities of freshwater game fish, deer, and wild turkey, tarpon, or other wildlife without a license. So this is one of many examples of where the licensing requirements kind of dovetail with the criminal code violations. All right, but we also have felonies associated with improper hunting practices. A level 4 or felony is a person who, under 379.401 Section 4, kills a Florida or wild panther, kills or wounds any endangered, threatened, or species of special concern, which are categorized under the Endangered Species Act and Florida's equivalent, or killing, injuring, possessing, or capturing of alligators or crocodiles or their eggs. That last one surprises a lot of people because you just kind of assume that it's open season on alligators. Well, it's not, and it's a highly regulated area as well. There are also other prohibitions relating to spiny lobsters, stone crabs, blue crabs, deer, wild turkeys, etc., which can give rise to level 4 violations. Okay, well, let me focus now more broadly on the Florida cruelty statutes relating to animals in general, okay? This isn't specific to wildlife, but it's relevant to
Israeli actions and are trying to make sure that can move forward with a ceasefire. But it's been
sorry, I'm hearing some noise in the background. I don't know if you all can hear that too.
Of U.S.
Sorry, there it went away. Okay, thank you. Sorry. So the omnibus animal cruelty law is Section 828.12 of the Florida statutes, and it provides that any person who, among other things, unnecessarily tortures, kills, or harms an animal in a cruel or inhumane manner commits animal cruelty, which is a misdemeanor of the first degree, and it's coded to the criminal penalties that are contained in Section 775.082. And then, much as we just discussed with regard to the specific wildlife criminal code, any person who intentionally commits an act to any animal or person which they have custody or control of, which results in the death or excessive or repeated infliction of unnecessary pain or suffering, is a felony of the third degree. And again, you see the penalties there. In addition to that, if it is determined that a violation includes the knowing and intentional torture of an animal that injures, mutilates, or kills the animal, it is required that they pay a fine, but also undergo counseling and even anger management, kind of an interesting, more contemporaneous type of penalty that's in the Florida laws. Subsequent violations, repeat offenders have additional charges. And then the last provision on this slide, anyone who commits multiple acts of animal cruelty or aggravated animal cruelty may be charged with a separate offense for each act. and separate offenses such as cruelty where that's committed. So again, we have a very robust criminal code that relates to animal cruelty specifically. Okay. Just going on into a little more detail here, section 82802. In this chapter and in every law of the state relating to or in any way affecting animals, animals shall be held to include every living, dumb creature. And then it goes on to define torture, torment, cruelty, etc. And the owner in person can include corporations, knowledge and acts of agents and employees, etc. So again, very, very, very strong language here. Okay. So I wanted to get through kind of the basic foundation laws that will now allow us to focus more attention on House Joint Resolution 1157. This passed in the preceding legislative session, which allows for Constitutional Amendment 2 to be included on the November 5th general election ballot. Okay. Well, let me start with sort of the basics. Okay. This came through the legislature. In Florida, there are 3 ways to amend the Florida Constitution. One is through a legislative resolution, such as you have here, passed by both houses and approved by the governor. Another is through the Citizens Petition Initiative, which I'm sure most of you are familiar with. You know, you're standing in the grocery store and someone comes up with a clipboard and says, hey, will you sign this? That's the other way. And the third way is a little more unusual and less frequent, and that is every 20 years in Florida, unique to our state, we have a Constitution Revision Commission which meets. And they consider amendments to the state constitution, which are then, if approved, presented to the voters. One of my favorite of these is the animal law section, in conjunction with other groups, was successful in having the greyhound racing ban put on the Constitution a couple years ago, 3-4 years ago, which was voted on successfully by the public. And now we do no longer allow commercial greyhound racing in Florida. That's an example of where that comes up through the Constitution Revision Commission. One of the unique features of a legislative initiative to place something on the ballot to amend the Constitution is, unlike the other two, it's not subject to judicial review, which of course gives the legislature a lot of power here to put these things on the amendment. By contrast, for example, with respect to the commercial greyhound racing amendment, that was challenged by the racing industry, starting in circuit court here in Leon County, which ruled against the people who were trying to prevent greyhound racing, including the Florida Bar Animal Law section and other groups. It was directed specifically to the Supreme Court because it was a matter of great public importance, so it bypassed the District Court of Appeal review, and the Florida Supreme Court overturned the circuit court and held that it did pass muster under the requirements for placing a matter on the ballot. It was placed on the ballot, and almost 70% of those voting voted in favor of it. Well, that process doesn't apply to a legislative resolution, okay? Basically, a yes vote on Amendment 2 establishes a constitutional right to hunt and fish in Florida. More on that in a minute, okay? So let's talk about the actual language. I think it's important to read it. Proposing an amendment to the state constitution to preserve forever fishing and hunting, including by the use of traditional methods, as a public right and preferred means of responsibly managing and controlling fish and wildlife. Specifies that the amendment does not limit the authority granted to the Fish and Wildlife Conservation Commission under Section 9 of Article 4 of the state constitution, which we just discussed, okay? Now, I'm going to parse this for the sake of the rest of this discussion here into 2 parts. The first part is the amendment to the Constitution to preserve forever fishing and hunting as a public right. Okay, let's stop there. I mentioned a few slides ago that already in the Florida statutes, specifically entitled Right to Hunt and Fish. Is this right? So one of the questions is, why do we need this? Why do we need to put this in the Constitution when it's already a statutory right? We'll talk about that more later. But I think the real focus here, particularly those that have a concern about this amendment, is the second part, and that is that hunting and fishing not only are a public right, but are a preferred means of responsibly managing and controlling fish and wildlife, okay? So we're going to talk about that more next. Again, the joint resolution, which was approved by both houses of the legislature and approved by the governor, will be on the ballot on November 5th. As I mentioned, it seeks to preserve hunting and fishing as a public right. But and I don't think most people have a problem with that first bullet. Of course, as I said, it's already a public right. Some of the arguments in favor of putting it on the Constitution I have heard is, well, a statute can always be changed, where, based on, the political parties in power at any given time, the whims, if you will, of the legislature, the usual things that go into making law. Whereas if you put it in the Constitution, it's probably there forever, and it is harder to change. It's not impossible to come back and amend it, but it's very difficult. The other thing too is it requires a supermajority of voters. So in this case, 60% of the voters would have to approve it, and that gives the citizens, the voting citizens of the state of Florida, some control over the fundamental rights that are contained in the Florida Constitution. Maybe they don't have that control as general voters, general public in the legislative process. So again, I think most people get that first part, understand, the rationale, whether it's necessary or not can be reasonably debated, but it doesn't really do much of anything to change the existing status of the law, which again allows for hunting and fishing as a public right. But I think where we get into some more controversy here is that the use of the terms preferred means of wildlife management. Now, let's back up to some of the earlier slides that I mentioned. The FWC, having been delegated both by the Constitution and by the legislature in the form of statutes, is the agency that's charged with the responsibility to regulate hunting and fishing. And among their regulations that are extensive are wildlife management techniques. It is true that in some cases, hunting and fishing are considered legitimate methods for wildlife management, okay? This goes a little bit further by calling it the preferred means of wildlife management, okay? And then that third bullet, which we'll get into a little bit more as well in a minute, creates a protection for quote unquote traditional hunting and fishing methods, okay? Let's break that down a little bit further. One of the proponents and key sponsors of the bill said that the purpose and intent behind this is to protect hunting and fishing because some states are outlawing this practice. Now, I have done some research. I haven't seen any evidence that hunting and fishing are being outlawed in any state. Also, another one of the sponsors pointed to an Oregon initiative, didn't make it to the ballot, but it was a citizen petition to include on the ballot to remove certain animal cruelty exemptions from the code, including practices related to hunting and fishing. The bottom line is, I'm not aware of any specific evidence of any threat in Florida of hunting and fishing being outlawed. None of the wildlife groups, the credible ones that I'm familiar with, that I work with, or any individual wildlife advocates, to my knowledge, have ever suggested, at least not seriously, that we should outlaw hunting and fishing, okay? And then there's other comments that have been made in the record of the legislature that, it's important to preserve the culture, history, and economy of Florida. But again, I will say there's no current or looming threat to hunting or fishing in our state. Okay? I just think it's important to understand that. It is true, as I mentioned earlier, that putting this into the Constitution does add somewhat of a higher level of protection, if you will, over and above a statute. Okay, and I think that's fair that most people would agree with that. It does create protection that would prevent any future regulation from outlawing hunting and fishing. In the extremely unlikely event that 379.104, the statutory right to hunt and fish, is repealed. So it's a bit of a stronger protection. Okay, I think that's fair to acknowledge. But again, as I said earlier, where we get into some trickier issues is the preferred methods of responsibly managing fish and wildlife and protecting so-called traditional methods. Well, let's talk more about what that means. This comes down to the key terminology and the area of concern in this amendment, and that is the preferred means language. Qualifying hunting and fishing as a constitutional right or constitutional rights is not inherently dangerous to fish and wildlife, okay? You could bicker about overfishing, overhunting, violations that might occur, whether the FWC has sufficient personnel to be able to cover the vast areas of Florida, land and water, where hunting and fishing take place. But those are really more implementation issues. Again, hunting and fishing as a constitutional right in and of itself is not inherently dangerous. But I think where the concern is to say that this is the preferred means of regulating. And let's break that down. First of all, there are other non-lethal alternatives in order to manage wildlife other than hunting and fishing. And let's not, use euphemisms here. Hunting and fishing means killing wildlife and killing fish. And I think the concern would be, why is killing them a preferred means? I think even if the language said a means, it would be consistent with current law and current wildlife management practices. But what this amendment would do would be to codify in the highest law of the land, the Florida Constitution, that killing wildlife and killing fish is the preferred methods of managing them. Well, managing does not mean killing them. Okay, it means what its common language suggests, managing them. And remember, the FWC, it's the Conservation Commission. It's not the Protection Commission, it's the Conservation Commission. So you would expect that there might be a non-lethal alternative, and there are non-lethal alternatives to killing wildlife and fish in order to manage their populations. Okay, the fear here is, and I think it's a legitimate fear, is that calling this the preferred means of managing it would tip the scales in favor of a variety of things that are not possible today. Broader hunting seasons, more relaxed hunting and fishing regulations, the possibility of another bear hunt, the first one in 2015, more on that in a minute. And to be fair, while this language does not mandate hunting and fishing as the first approach, it would present a stronger backing for these practices should a management technique come under litigation. And let me give you one example. If another bear hunt is authorized, and the FWC is doing some research right now, it says, to consider that, it would arguably provide a constitutionally backed rationale that would support the use of a hunt for managing bear populations, even if other non-lethal means would be effective. Let me elaborate a little bit on that last point. As I said, Amendment 2 would protect hunting and fishing by traditional methods, but it's not specifically defined. And let me give you some examples. One traditional method that's currently banned by FWC is the use of steel leg traps. They're very brutal, very inhumane. They're used to capture and kill animals, primarily for pelts. The steel leg trap closes around the leg of the animal. They're particularly cruel. Animals have been reported to engage in self-mutilation to escape. They're exposed to increased risks of injury, including from the trap itself and from predators. When the amendment, if it were to pass, provides that the amendment does not limit the authority, people say, well, okay, doesn't that cover us here? Well, it only says it doesn't limit their authority. It doesn't say that they can't exercise that authority in a manner consistent with the provision that you should protect traditional methods, and it's the preferred method of management. Okay, so it doesn't limit the ability of the FWC to loosen these restrictions and possibly eliminate them. It is, I believe, a serious potential attack on the level of protection, because it would create a carve-out in the Constitution that allows FWC to regulate methods for hunting and fishing that are less stringent than right now. I think that this is more than just idle speculation. We have already heard from a number of interests that if they see, as passed by the electorate and written into the Constitution, a constitutional right with language that says that this is the preferred method, that they believe that a number of the current restrictions and prohibitions in place under the FWC would have to go away. And I think that I predict that if this passes, you will see that. You will see people approaching the FWC to loosen some of the restrictions that exist right now. Well, let's talk about one of my favorite topics, just to elaborate a little bit on the concerns, and that's the Florida black bear. I believe that one species that would be especially at risk if this amendment were to pass is the Florida black bear. It has a very troubled history. It was on the brink of extinction as recently as 1974. It was faced with excessive hunting, which led to its population to fall shockingly to just 300 individuals in the 70s. Through conservation efforts led by the FWC, the species grew back to roughly 3,000 individuals and is no longer considered threatened or endangered as of 2012. However, as a result of that lessening protection, the FWC authorized a hunt. Frankly, while arguments were made that, similar to what I think will be made under Amendment 2, that we need to manage and control the populations of the black bear, there was really no evidence that that was the case, nor is there today, that, black bears have been cited attacking, neighborhoods or animals. It's just not a thing that's really happening, certainly not to the point that we should authorize a hunt, okay? Now, I won't go into much of the details. I was actually part of a group that opposed the first hunt. It was a debacle, to say the least. It was supposed to last 1 week, and it only lasted a couple days. Many illegal kills were recorded, including the deaths of lactating mother bears, okay? I believe that should Amendment 2 pass, it will be easier to authorize a similar hunt in the future. It would favor allowing controversial hunts instead of erring on the side of caution. Okay, again, this goes back to the language of Amendment 2. If killing a bear is a preferred method for managing bear populations, then I think you could see how an argument could be made that this should be allowed, and in fact is authorized as a right in the Florida Constitution. There's a little bit of background information here. Human-bear interactions have increased drastically, in part due to booming development, but there is no evidence that bears have killed or injured humans or even pets, very little. That which exists is anecdotal at best. One of the interesting things is, and let's talk about non-lethal methods of managing wildlife, in this case, black bears. In every community in Florida and other states where bear-proof trash cans have been deployed, the bears go away. They can't get in them, they go away, and no more harm is found. That's just one example. Other examples of non-lethal ways of managing black bear populations other than shooting them are securing attractants such as garbage, promoting land management techniques, educating the public on humane ways of scaring bears away. Yes, they do exist. Loud noisemakers and other ways to manage it. And there's actually a plan by the FWC to use non-lethal methods. The question would be, if preferred means include suddenly hunting, well, then maybe these non-lethal methods go away. Okay, well, that's just a little bit on wildlife. Let's talk about fish, okay? Gill nets is another area that there's great concern about what the implications would be of Amendment 2 passing. Gill nets are a traditional fishing method, okay? And remember, the amendment says that it preserves these traditional fishing methods. Gill nets were authorized in Florida by an amendment, a constitutional amendment in '94. Gill nets and seine nets were historically used by fishermen in Florida. While they allow for large numbers of fish to be caught, they present the issue of bycatch, which means that non-target species are caught, and that includes dolphins, other fish, whales, turtles, and any other fish or marine life that could be caught in the nets. I'm going to go again on the record of making another prediction that I believe that should Amendment 2 pass, based on the argument that it's now a constitutional right and a preferred method of managing fish, that commercial fishermen will seek to invalidate the net ban. What that does create is an interesting tension between two constitutional amendments, one that outlawed it in '94 and the one that, if it is passed in 2024. And generally speaking, it's a matter of constitutional interpretation that if a later one relates to the same subject matter, it would arguably supersede the previous one. Okay. Well, let's talk about some of the specific types of legal challenges. Again, I mentioned gill nets, I mentioned bear hunting, some other methods that are considered traditional methods of fishing and hunting, which are now not permitted. Early fishermen used electric shock and explosives as a means of capturing fish, okay? Past methods for hunting alligators included baiting grappling hooks and then fastening the hooks to trees. Fur trappers used steel leg traps to capture animals. Again, the concern here, and I think it's a legitimate one, is that some of these so-called traditional methods of hunting and fishing, because they are specifically preserved by the constitutional amendment and in conjunction with the provision that it is the preferred method of managing fish and wildlife, notwithstanding existing prohibitions, would authorize, if not require, through litigation, if it ensues, the FWC to relax or eliminate some of these prohibitions or restrictions on traditional methods of hunting and fishing. Again, I think this is a very serious concern and one of the main reasons why this amendment could be troublesome. Again, talking about the net ban, in '94, because of overfishing and bycatch, the use of these entangling nets was prohibited or restricted. An entangling net includes ones such as gill nets and trammel nets. Seine nets are limited to 500 square feet. Amendment 3 was highly controversial, sparking intense debates between commercial fishermen and environmental activists. Again, should Amendment 2 pass, it creates an amendment that is at odds, arguably, with the 94 net ban. And as I said, a constitutional amendment may modify an existing amendment when it relates to the same subject, adopted for the same purpose, and when they cannot be enforced simultaneously without creating a substantial and material conflict. While it is arguable that these two amendments have different purposes, how can you enforce both by upholding the ban and allowing for other presently lawful traditional methods? And it's not clear exactly, frankly, how the legislature and the courts would respond to this. I do think it is fair to say that Amendment 2 would limit the ability of the legislature and local municipalities to regulate any matter that might have an effect on hunting and fishing. While preventing a ban is the goal of the amendment, it could potentially also ban certain changes to hunting and fishing regulations, which the FWC may deem necessary in the future to protect wildlife and fish. With regard to local governments, the state has already preempted the local application of hunting and fishing regulations. It arguably could prevent courts from upholding regulations that could have an impact on the practice of hunting and fishing. Now, there's not a lot of case law out there, as you can imagine. I will point out, and this was one of the arguments made during the legislative session, 23 states have constitutional provisions that protect the right to hunt and fish, okay? And other states are considering doing that. And as I mentioned earlier, it's not the codification into the Constitution of the right to hunt and fish that's concerning. These other states, for the most part, don't have the preferred methods language, and that's where the concern here is. But this one case that we did locate out of Pennsylvania in 2014, Hunters United for Sunday Hunting versus the Pennsylvania Game Commission, I think casts some light on what the concern is. The plaintiff sought an injunction against the Pennsylvania Game Commission, which is the equivalent of Florida's FWC, which had a rule that prohibits hunting of certain animals on Sundays. The court ruled in favor of the Game Commission, arguing that absent any constitutional protection of the right to hunt, such a regulation was not in violation of the plaintiff's Second Amendment rights. The court reasoned that had Pennsylvania had a constitutional amendment similar to the one proposed in Florida, this rationale would not have existed, and thus cases brought against a regulatory or other body such as the FWC would fail even if the regulation was based on a legitimate government interest and sound evidence. And this is the fear here, that, and let me go back and read this, absent any constitutional protection of the right to hunt. So arguably, if Florida were to have a constitutional protection, it could be held that any attempt by the FWC to restrict or prohibit certain hunting or fishing activities would violate the constitutional amendment. Okay, well, as I said, it will be on the ballot on November 5th. It will require a 60% vote to pass. The important point here is that public awareness is crucial, as many voters may be persuaded by the idea of protecting hunting and fishing, but not realize the full impact of using it as a preferred method of managing wildlife. And let me pause there. As Laura mentioned, I teach classes. I'm teaching one at FSU Law and one at Stetson Law this semester on animal law. And, these are very bright law students, thoughtful, they think through issues. Many of them, not all of them, are animal welfare advocates. So I read the amendment to them and just coldly, without asking them, without explaining my concern and the implications of it, what do you think about it? And most of them couldn't get past the first part or didn't bother to read the rest of it. All they saw was, well, hunting and fishing is a public right. Okay, what's the big deal? The concern is that the typical voter, no disrespect intended, isn't going to be able to get past that part either. And remember, that's the title of the amendment, right to hunt and fish, similar to the statute. When I explained, however, to these law students the concerns about the preferred method language and what the impact might be on the ability of the FWC to regulate wildlife, they said, oh, wait a minute, that's a different story. Well, sadly, there won't be any law professor standing there at the ballot when people are voting to explain all this to them. And there is an effort to try to educate the public on what the implications are. And but unfortunately, like with many of these things, the pro amendment forces are very well heeled and have a massive budget, and you're already starting to see some of their pro hunting and fishing ads pop up. The bottom line is that there's no present threat to hunting and fishing in Florida. There hasn't been and there won't be. The current laws are adequate to protect hunting and fishing and to strike a balance between the right to hunt and fish and the conservation and management of wildlife and fish. It really is an unnecessary amendment, and I think it will cause an unacceptable heightened risk to our state's wildlife. And that's the concern that we all have. Now, by the way, I just put the front page of this excellent article by a couple of my former students in the March-April 24 issue of the Florida Bar Journal, qualifying hunting and fishing as the preferred means of managing wildlife, a potentially dangerous ballot initiative that provides little protection to hunters and fishermen. Highly recommend this article. It's a very, very compelling discussion of the amendment that we were just discussing. Before we conclude and take questions, I want to read just a couple of examples of some of the people that are pro and con, some of the groups. And this will, I think, tell you all you need to know about where the concerns lie. So some of the organizations that have been vocal supporters are funding some of the efforts, lobbying efforts, and public outreach efforts include the American Sport Fishing Association, Backcountry Hunters and Anglers, Bonefish and Tarpon Trust, Delta Waterfowl, Florida Airboat Association, Florida Sportsmen's Association, Future Hunting in Florida, National Shooting Sports Foundation, which is affiliated with the NRA, and others, okay? Just, by way of opposition, some of the organizations that are against this include, sorry, give me a second, Humane Wildlife Consulting of South Florida, American Ecosystems, Animal Wellness Action, I believe the Animal Legal Defense Humane Society, other groups like this. So it's pretty clear what you're seeing here is a breakdown between traditional hunting and fishing organizations and traditional animal welfare organizations. Not unusual, okay? I do want to read a quote from somebody I know well, Clay Henderson. He's the president emeritus of the Florida Audubon Society, a very respected individual and organization. This amendment goes too far in declaring this right to hunt and fish as a public right. No other right in our Constitution is described in this way. It seems to imply this right is even more important than our other fundamental rights. Perhaps it means the right to hunt is more important than one's right to possess and protect property. The language in the original NRA proposal states, this section shall not be construed to modify any provision of law relating to trespass or property rights, but the legislature didn't include that restriction. The biggest concern for me and other conservationists is that it proclaims hunting and fishing as the preferred means of responsibly managing and controlling wildlife. Often the preferred means to conserve fish and wildlife is to limit hunting and fishing to protect their numbers. That's why we have limits on the size of fish that can be taken in seasons for hunting. These are reasonable rules to protect numbers of fish and game. Populations of grouper, red snapper, and redfish have been severely regulated as their numbers have declined. Allowing more fishing will not increase their numbers. We don't allow bear hunting because the bear population is confined to isolated areas and may not be sustainable. Many of us think this proposal is just a door to bring back bear hunting. As one of a few lawyers who have drafted most of the environmental provisions of Florida's Constitution, I can tell you that every word matters in a proposed amendment. That's why another section of this proposal is scary. It proclaims this right to hunt and fish includes the traditional methods shall be preserved forever. What does this mean? To me, it clearly means the return to steel jaw traps, spears, spearfishing, gill nets, and other inhumane means of hunting and fishing. Okay, well, I also included here, as we wrap up the presentation, some of the key sources, which I urge you to take a look at. And that's my co-author, Savannah Sherman, again, one of my former law students, is now in the lovely state of Hawaii. So I think now is when we want to set aside some time to see if we have any questions. Laura, do you see any there?
Yes, and Ralph, I just want to say excellent job on not needing a reminder to watch your clock today.
Thank you.
So the question that we have right now is, how is the preferred means, not a mandate, that hunting is the first option?
Well, I think that it can be considered a mandate, because if the amendment says that hunting and fishing are the preferred methods, that sounds like a mandate to me. Preferred means what its common language suggests. This is what you should be doing.
Okay, that makes sense to me. For the CLE course number, you just have to hang on till the end and I will give it out. I promise. Sorry, that was an actual question. And then someone else asks if there's anything that folks can do to get the word out to oppose this amendment.
Well, I appreciate that question. I mean, again, we're up against a 10-to-1 budget deficit when it comes to the money that's being spent by the proponents of this, those organizations I just read. But I have great confidence and faith in the electorate. With respect to the Greyhound Amendment, we were outspent 2 or 3-to-1 by the forces of commercial racing and other interests, and the people who understood the implications showed up and voted. They're expecting a strong voter turnout because of the candidates and the issues that are out there. I would just use the traditional methods of word of mouth and going on social media, telling everyone you know and telling everyone you know to tell everyone they know. If you want to step up your involvement, reach out to one of these environmental and animal welfare groups that I mentioned, and there are many others, and see what you can do to support them. But again, I have great confidence in the grassroots efforts of people. That's really the only thing that can overcome the big money interests that are promoting this amendment.
All right, and then I have two folks who simultaneously asked if this PowerPoint is going to be publicly available so that they can use it to educate others.
It's okay with me.
All right, we'll get with our bar liaison and see if we can get this sent out to everyone who attended today. And then we also have a question. Any thoughts on the use of RICO for hunting violations? Is this something that's being suggested to the AG's office? And then they indicate that they recently had a case where this was used for hunting with the dogs.
You know, that's a really excellent question and theory. RICO, I have been involved in some RICO cases, not in this context. And certainly, if you can show the kind of joint effort to engage in criminal activities that is the underlying legal principle of the racketeering laws, I think you could make it fit. I can imagine, though, that it would be a very, very difficult to do. But yeah, certainly, we'd want to look at all of the options here if we want to try to prevent these activities. I mean, I want to say again, the concern here is not with hunting and fishing per se. It's with rollback of the restrictions and limitations that exist now to conserve and protect wildlife. And I think that's where the real fear comes in.
All right. Then there's a question about whether the committee is formally lobbying against Amendment 2.
The committee,
I think they mean the section.
No, we are not.
Yeah, I think that's the best answer, is that no, it's not a formal position of the section. The goal today is just to let everyone know what the concerns are and to educate on what things are kind of going on with this amendment behind the scenes.
Yeah, and I guess a disclaimer maybe isn't necessary, but while I'm presenting this on behalf of those two sections, these are my personal views.
Oh yes, good. Always good to do a disclaimer. All right, so with that, that answers all of the questions that we had. So thank you so much, Ralph, for taking the time today to help give us some background and some context for this amendment that we're going to see on the ballot this fall, and especially some of the potential criminal implications and consequences. And thanks again to everyone who attended. The CLE course number is 8688. Again, that CLE course number is 8688. All right. Thank you, everyone. I hope everyone has a great rest of their day.